Hello and good day to everyone. This is Attorney Angel. May I refer you to Part 9 of our syllabus on Amendment and Repeal. For this week's lecture, I will be discussing about the concepts, principles, and rules of construction on Amendment and Repeal. But before we do that, may I just remind everyone to please read the cases listed under this topic. I will leave them up to you. I trust that you will read and study these cases, or that you have already read and studied the cases listed for this topic. Okay, so before I proceed with the lecture, may I invite everyone to join me in a short prayer. Dear Lord, we praise you, we glorify you, we give you thanks. We ask for your mercy and forgiveness for our shortcomings, and we lift up to you all our special intentions. Please protect us from COVID-19, and please end this pandemic, and please guide us as we struggle and survive through this crisis. Keep us safe and healthy always. So let us proceed with the lecture. So the topic for this week is Amendment and Repeal. Okay. Let's go first to amendment. When you see or hear the word amendment, what comes to mind? Okay, what comes to mind is the root word amend, which means change, modify, or alter. So amendment means alteration, modification, or change. To amend means to change something, to modify something, or to alter something. So here, we refer to the amendment of a statute or a law in statutory construction, or we call it, or we refer to it as an amendatory act. So next question we need to answer is, what is an amendatory act? An amendatory act or law either, as we said, from its definition, operates to change, alter, or modify the original law or statute, or it adds something or makes an addition to the original law. So, when does an amendment take place? Okay, but first, remember that our premise is that for an amendment, there is an earlier law or an original law that we are referring to. Okay. So when does an amendment take place? Or when is an amendment of a law or statute effected? The answer, the amendment takes place, or an amendment is effected when the amendatory act is enacted, and what happens is that it modifies or alters some of the provisions of the earlier statute or of an original statute. And how does it happen? The amendment can either be an express or implied amendment. So the next thing we need to know is, when is there an express amendment and when is there an implied amendment? Okay, let's go first to express amendment. There is an express amendment when the amendatory act itself specifies or specified the provisions of a particular statute that are amended. And on the other hand, there is an implied amendment when a part of a provision, when a part of a previous or prior law or earlier law or statute embracing the same subject matter has become inconsistent with or irreconcilable with the new provisions as amended. Okay. As to the rules of construction on amendment, we have 4. First off, we have this rule. A statute and its amendment should be construed in its entirety or as a whole. The amendment becomes part of the original statute as if it had always been contained therein. Okay. Next is that provisions of the original act which are not affected by the amendment shall remain in force and in effect. Third, the amendment made indicates that the legislature intended a change in the law or in its meaning. So therefore, what should the court do? The court should give effect to such intent. And fourth, as a rule, the amendatory act operates prospectively unless otherwise provided, or if it could be implied from the language used that the legislature intended or intends to give it a retroactive effect. However, or even so, if the legislature intended it to give it a retroactive effect, even so, the amendment cannot be construed retroactively if it will impair vested rights or if it will impair the obligations of contract. Okay. So it's just a short discussion on amendment. Okay. We move on to repeal. Okay. Repeal connotes rescission, annulment, revocation, termination, abrogation, cancellation, or abandonment, and other synonyms. Okay. So to repeal means to abandon, to terminate, to nullify, to invalidate, to cancel, or to rescind. Okay. So with respect to laws or statutes in statutory construction, we refer to them as repealing acts or a repealing act. And what is a repealing act? Okay. A repealing act is an act which, from the meaning itself, revokes or terminates another statute or law. And just like in amendment, how is it done? It can either be done by express language or by implication, or it can be done expressly or impliedly. Okay. There is no problem with respect to express repeal, since usually the repealing act lists down or enumerates the provisions that are repealed. Like for example, you have taken up your persons and family relations subject in Article 254 of the Family Code. It particularly enumerated the provisions of the new Civil Code and the provisions of the Child and Youth Welfare Code, which were repealed by the Family Code. Okay. But as to repeal by implication or implied repeal, it can be done in two ways. So the first one is by covering the whole subject matter so that it is intended as a substitute for the earlier statute. Okay? And the other one is that it can be done by containing provisions which are inconsistent and irreconcilable with the earlier statute. Okay. Same example, same article, Article 254 of the Family Code. The second sentence thereof states that all laws, decrees, executive orders, proclamations, rules, and regulations, or parts thereof, inconsistent therewith, are hereby repealed. So, even if it mentions the regulations, the rules, proclamations, EOs, etc., this is an implied repeal. This is considered an implied repeal or repeal by implication because unlike in the first sentence of Article 254 of the Family Code, you can check it out. It lists down specifically and particularly, or that it specifically identifies or particularly identifies the provisions of the new Civil Code and the Child and Youth Welfare Code. Or but here it does not. It does not designate the acts which are to be repealed or are intended to be repealed. So it is an implied repeal. Okay. In the case of Nicano versus the Commission on Audit, the Supreme Court gave a lengthy discussion on repeals and implied repeals. So let me just restate to you the important principles enunciated by the Supreme Court in that case. Okay. So according to the Supreme Court, repeal by implication proceeds on the premise that where a statute of later date clearly reveals an intention on the part of the legislature to abrogate a prior act on the subject, that intention must be given effect. So before there can be a repeal, there must be a clear showing on the part of the lawmaker that the intent in enacting the new law was to abrogate the old one. The intention to repeal must be clear and manifest. Otherwise, at least as a general rule, the later act is to be construed as a continuation of and not a substitute for the first act, and will continue so far as the two acts are the same from the time of the first enactment. Okay. Now, let me just go back to Article 7 of the New Civil Code of the Philippines, which is considered as the legal basis of the implied repeal. So, Article 7 of the New Civil Code of the Philippines is explicit in its provision, which states that laws are repealed only by subsequent ones, and laws are repealed either expressly or impliedly. However, remember that implied repeals are frowned upon, and they are not looked upon with favor. Okay? Such that if both statutes or laws or two or more laws can stand together and if they can be harmonized, then there can be no repeal or there is no repeal. Okay. In the same case of Nicano versus COA, the Supreme Court also stated that it is a well-settled rule of statutory construction that repeals of statutes by implication are not favored. The presumption is against inconsistency and repugnancy, for the legislature is presumed to know the existing laws on the subject and not to have enacted inconsistent or conflicting statutes. Okay. The court further explained the principle in detail. So the court stated that repeals by implication are not favored and will not be decreed unless it is manifest that the legislature so intended. As laws are presumed to be passed with deliberation with full knowledge of all existing ones on the subject, it is but reasonable to conclude that in passing a statute, it is not intended to interfere with or abrogate any former law relating to some matter, unless the repugnancy between the two is not only irreconcilable, but also clear and convincing, and flowing necessarily from the language used, unless the later act fully embraces the subject matter of the earlier, or unless the reason for the earlier act is beyond peradventure renewed. Hence, every effort must be used to make all the acts stand, and if by any reasonable construction they can be reconciled, the later act will not operate as a repeal of the earlier. Okay. So, still on the topic of repeal, repeal can either be total or partial. Okay. So, when you say total repeal of a statute or a law, the statute or the law is revoked completely. Okay. But when you say partial repeal, only the portions or portion not affected by the repeal will continue to exist. Okay, we've come to the last part of this lecture on amendment and repeal. Okay. This somewhat summarizes our discussion for the whole lecture. Principles and rules on amendment and repeal. Okay. So, first off, whenever the question of whether a law passed or a statute passed on a later date prevails over a law enacted on an earlier date is raised, it necessarily involves the question of whether the later law amended or repealed the earlier law. Okay. So in this case, it is important to apply the relevant rules of construction in determining whether the statute or law should be construed as having amended or repealed another law or the other law. So in line with this, I view it as the three-tiered steps of construction of or rule of construction on amendment and repeal. So it also summarizes the discussion for this topic. Okay. First step or first tier. So whenever there is an absence of an express provision stating that the later law amends or repeals the earlier law, what you should do is to harmonize the two laws and see if it can be given effect in their entirety. So harmonize the two laws and see if each can be given effect in their entirety. Now, if not, then you go to the next tier or to the next step. If these laws or statutes cannot be reconciled, go to the next tier or to the next step, which is to consider the various special laws in interpreting statutes in pari materia. Okay. Speaking of in pari materia, just a review, we discussed in pari materia earlier, also in the Latin maxims or legal maxims. Okay. So when we say statutes are in pari materia, means statutes relate to the same person or a thing or to the same class of persons or things or objects or cover the same specific or particular subject matter. So going back to our lesson before in pari materia, the general rule in the construction of statutes in pari materia is that they should be read and construed together as to form a complete, a coherent, and intelligible system. So to implement this, prior statutes relating to the same subject matter should be compared with the provisions of the new statute or the new law. And if possible, by reasonable construction, both statutes or laws should be construed in such a manner that will give effect to the provisions of each statute. So in the case of Declarador versus Gubatan, the Supreme Court said that case law has it that statutes in pari materia should be read and construed together because enactments of the same legislature on the same subject are supposed to form part of one uniform system. Later statutes are supplementary or complementary to the earlier enactments, and in the passage of its acts, the legislature is supposed to have in mind the existing legislations on the subject and to have enacted the new act with reference thereto. So statutes in pari materia should be construed together to attain the purpose of an expressed national policy. Okay. So if this does not apply or if it is not applicable, the last resort is the third step or the third tier, which is to consider the later law as amending or impliedly repealing the earlier law. So harmonize, apply special rules in pari materia, then if not, consider amendment or repeal. Okay, so that's it for this lecture. But before I say goodbye to you, may I just remind those who have not yet submitted, posted, or uploaded their infographic and infographic report or presentation to please submit and upload and post your infographic and infographic report or presentation since it is equivalent to your midterm exam. Okay? And again, Reminder, for the cases, as I earlier mentioned, I trust that you will read and study, or that you have already read and studied the cases listed for this topic or on amendment and repeal. Okay? So with that, thank you very much for listening and watching. Stay safe, stay sane, stay healthy. And of course, always pray and or always remember to glorify God with a grateful heart. Thank you very much.